And then the stonewalling and game playing began. And that's when it started to become clear that something is off with this case.
The result is astounding. Your client comes in having lost 2 properties due to predatory lending and leaves with 2 properties with no mortgages.
What was happening was the weaponization of the rules in order to obstruct and stonewall and deprive people of their day in court.
One Great Case, a podcast about law to learn more about people. I'm your host, Areta Lloyd.
Today we are joined by Neil Colville-Reeves, named partner of a litigation boutique in Toronto. Neil has a general commercial estates and insurance litigation practice with a large, diverse subrogation practice in construction, engineer liability, oil spills, product failures, infrastructure, among other areas. Neil, you and your partner hung out your shingle not so many years ago, and I see you're over a dozen lawyers now. That is an amazing accomplishment. Aside from what people can learn about you from your bio found online at reevesrichards.com, tell me something about yourself that's a little surprising and definitely not law related.
Well, thank you, Areta, for inviting me onto the podcast today. It's nice to be with you. Well, I'm a father of 2 daughters, and I spent many years in hockey rinks watching my daughters play hockey in the day. And over many years, I've spent many hours with now other middle-aged men like myself, and some of their daughters, in fact, playing in a garage band. So we play in a band. We do quite a bit of gigging for charity. We participated a number of years in a law-related charity event called AIDS Beat. We've done work with sick kids fundraising for charity, and last year we did a show at Revival in support of a company called Genwell, which is a company that is perfect for our age, that promotes people to get out into the world again and away from their phones and connect with people in person. As a father of 2 young women in their 20s, that's an issue that's become kind of near and dear to my heart, because I see people really married to their phones and not going out as much as they should. And so, in any event, there's a little non-law background.
Well, you got to tell me about the next event. I'm coming.
Okay, done.
You and I decided to speak about a typical fraud case that procedurally turned out to be anything but typical. The case is SEPUSAC and 9706151 Canada Limited, which was filed in 2018, I believe, and you only just received the last Court of Appeal decision last month. That's 8 years. Take us back to the beginning and when the case landed on your desk. Who's your client? How does legal troubles begin? And what did you think about the case at that time?
Well, my client arrived in my office in early 2018. And just by way of background, our firm, the predecessor to our current firm, so this firm has been around for almost 3 years, but it really is a successor to a prior firm called Shameless Company that was really exclusively a litigation boutique. So I've spent really the better part of 25 years practicing largely insurance-related litigation. So working for institutional clients. And over, a good number of those years, I had thought many, many times how I would like to break out and do other things and diversify my practice. But as you know, when you get into this business, you get funneled, and we live in a specialized world, and you get busy with your clients and with your practice and learning your practice area, and it's difficult to break out. In early 2018, I was sort of determined that if things came in the door that were non-insurance related, that I felt I could contribute to and could work with, I would take some chances. So my client arrived in my office in early 2018, and he was in bad shape. He owned 2 properties, one up in Bradford, Ontario, one in Caledon, and he had lost both of them. Both of them had been sold by a mortgagee. he was alleged to have been in default on the mortgage, and he was in effect homeless. He didn't really have money to pay legal fees. And I sort of thought, well, this is an interesting case. There were some things that looked a bit wonky to me. And I thought, well, this might be a good case to sink my teeth into and try and help someone in need of help. And that's how we got up and running.
So you said he lost 2 properties in rapid succession, and that seems strange. Tell us the facts of the case as you saw them at that time.
Okay, he owned these 2 properties, and he had a mortgage for about $320,000, and it was, like a lot of people, and as I've learned in this space as I've been doing more and more of it, people who get into the secondary lending market, borrowing from private lenders, often are chasing a dream. They're living in a nightmare, right? Because they're under financial stress. They can't pay their mortgage and they're at risk of losing their property. And they think, if I can just survive till tomorrow, I can make this work. And so he borrowed money from a secondary lender at an interest rate that, and I've never been involved in that market before. I've always, the financing I've done is through banks, where at that point you were getting mortgage loans for 3%, 4%, 5%. I think might have even been lower. And here I was looking at a mortgage agreement where my client had 1 year prior in 2017 agreed to pay 15% interest only, plus lending fees, which made the effective interest rate quite a bit higher. So he was not making smart decisions, because people get emotionally invested in real estate. And of course, if he couldn't pay a mortgage with a conventional lender at 6 or 7%, which is what he was getting. So he was in a sort of secondary financial institution mortgage, paying at 6 or 7%, and he wasn't keeping up. He was in default. And if you can't keep up at 6 or 7%, guess what's going to happen if you're borrowing at 15%? You're not going to be able to keep up. So in a very short period of time, there was an alleged default, and so he arrived at my office on, I think that was the 20th of February. The 35-day notice of sale issued by the mortgagee was sometime in late November. So the mortgagee had taken possession of these 2 properties without a court order, without even a statement of claims. There was no order for possession. But in Ontario, you can take possession of a property without court order if you could do it peaceably. And so if a property is vacant, you can do that. So he had lost both of his properties, and both of them, I did PIN searches, and both of them had been sold by the lender within about a week. And I know enough about real estate to know that the price that they had been sold for seemed well below market value.
Right.
All
So
the sales
first
had been.
you're talking about the predatory lending, but now when you find out about the sale price, that doesn't smell right.
It doesn't smell right. It looked like something was off, and not just the sale price, but the speed of the sale. So it didn't appear that one of the properties had been listed on MLS, but it had sold within, actually both of them were listed on MLS. One had sold a day after it was listed. The other had sold 5 days after it was listed. Both had sold within about 15 days of the first listing. And prices on a combined basis seemed very low. And so something seemed off. So I thought, well, something does smell not right here. So this is worth exploring. So we went forward and issued a claim.
And so what did your client plead? Was it fraud? Take us through the pleadings.
Well, that's a good question. It was not a model of pleading, I will say. I had to, as I indicated at the outset, I was not experienced in this space, and I was quite concerned about pleading fraud, because I know if you plead fraud and you can't prove it, you can suffer adverse cost consequences. And I didn't know enough about the case, so I sort of danced around the fraud word, and I pleaded improvident. I pleaded that the properties had been sold below market value to non-arm's length parties. in order to benefit everyone to the detriment of my client. And then I pleaded in the alternative that they were improvident sales, which was to cover off if they had been legitimate, they were just sloppy and improvident. And so I had both of those bases covered. I had effectively pleaded fraud, but I hadn't sort of hammered that label, if I can put it that way.
Right. And so at this point, you actually didn't know if the buyers were related to the sellers.
Did not know. Had no idea. They were all numbered companies, which was a bit of a red flag. One of them was a BC company that had been incorporated only shortly before the sale. And so there were, and as we learned later, all of these companies had post office boxes as their registered addresses. They didn't have real offices. Another red flag. But at the outset, I wasn't sure. So we sort of pleaded. We only named the companies. We didn't name directors personally. We didn't sort of get over our skis too much. So a bit of I call it a feeler bet.
And what happened next? How did you end up finding out what you found out? I don't want to give it all away. I want you to tell the story.
Well, we started with a motion for CPLs to try to sort of smoke out facts, right? So we brought a motion.
Let's explain what a CPL is, just in case.
Okay, CPL is a certificate of pending litigation, which is basically a registration on title, which gives notice to the world that this property is in dispute. So you can't get financing on a property. You can't sell a property if there's a CPL on it. So you bring a motion and you have to establish to the court that you have an interest in that land and that there is some controversy or some dispute that gives you some entitlement to the property. They're not easy to get. I mean, you can't just sort of wander in and get a CPL just by making some airy-fairy allegations. You've got to have there's got to be some meat on the bone. So we brought motions for CPLs.
Was
really
that on notice or without notice?
It was on notice, because that's another issue. If you bring these motions, like for Mareva, without notice, you've got to have everything buttoned down tight, or there can be adverse cost consequences. So we brought them on notice. One of the owners, turned out to be a part of the scheme. They didn't respond. For when it's an enduring mystery to me that one of the parties didn't respond, which turned out to be, in the long game, it was a very important piece of it. That very early on, the purchaser of the property in Caledon did not respond to our motion for a CPL, and we got it unopposed. And so that sat on title. The other property where the lender, who is also the principal of the mortgagee, is a lawyer. And he fought back hard on the CPL on the other property because he had a vendor take back mortgage on that property. So on that property, which was up in Bradford, we got sort of a comfort letter from the lawyer for the purchaser of that property. And this is another interesting little rabbit hole. That purchaser had title insurance, which was another indicator to me that maybe this is legitimate. I thought maybe this guy is legitimate because he's got title insurance, and he had Bennett Jones as his lawyer because that was who the insurer had retained. So that lawyer gave me a comfort letter that said, if we're going to sell the property, we'll give you notice so you can bring your CPL back on. So I thought, okay, I've got both of these properties sort of tied up for the time being. And then we moved on with the litigation.
And so tell us a little more about what happened next. You've got your sort of ducks in a row here. You have the elements that you have to prove. So what was going to be your next step? And did it go according to plan?
No, it didn't go according to plan. It went not according to plan. The next step was to just start prosecuting the claim. So produced our affidavit of documents, requested other affidavits of documents from the other parties, sought discovery dates, tried to keep things moving. And by way of background, in the insurance world, things move very slowly. Things move slowly in litigation generally in Ontario, but in the insurance world, people are dealing in large volumes of cases. So when we schedule discoveries, it's often a year down the road because everyone's busy. This case, I was trying to really move it forward aggressively. And I put my affidavit of documents together. I served it. I had it sworn. I did a discovery plan. And then the stonewalling and game playing began with the parties ignoring me. Some of them agreed to discovery dates. And then when we got close to the discovery dates, one of the lawyers, sent me a letter. I'm not retained anymore. I'm getting off the record. And so you've got to start over from scratch, new lawyer, new dates. And so it took almost a year, and I had to unilaterally serve notices of examination to get dates. And of course, no one showed up. And that's when it started to become clear that something is off with this case.
So you're sitting there in the court reporter's office and they don't show up.
Yeah, I mean, they hadn't served affidavits of documents. And so I kind of knew that something was off. And so I got certificates of non-attendance. And then I brought a Rule 45 motion to have the vendor take back mortgage on that one property paid into court because it was coming up. It was a 1-year VTB was coming up, and I brought a Rule 45 motion. Again, just trying to smoke out these people to get them to put in evidence about who was who and to sort of reveal who they were. Because at this point, the numbered companies all just had directors. You didn't know who the shareholders were. It was very opaque. And so I brought a Rule 45 motion, went out to Brampton. This is pre-pandemic. And the next part of the stonewalling, new lawyer shows up for that party, shows up the day of the hearing. I've just been retained and gets a delay, gets an adjournment.
I love that. The adjournment ploy.
The new lawyer, and it's the system is really not set. Our system is set up for people to deal in good faith, for lawyers to deal in good faith. And sometimes in that particular instance, the lawyer who was the new lawyer on file was from a reputable firm. And I think he was a dupe. I don't think he realized that he was being played and that he was being used as sort of a pawn. And the people who are in the middle of this scheme, they have a lot of money. I mean, they do this to a lot of people. And so they've got the resources, and these are little bits and pieces of money for them to hire a lawyer, get them to show up. And that's my sense of it, is that that's what was happening.
So, you're adjourned and
we've got to amend our claim because now I've decided I'm going to add the principals because clearly they're up to no good. And of course, the principals that I was adding, the one principal in particular, he wasn't agreeing to the claim being amended. So he forced me to bring a motion, forced me to prepare materials.
Your poor client who can't afford.
Well, yeah, or my poor me who wasn't getting paid. So, but that was the whole point of it, right? Is to make the people exhaust their resources so they eventually give up. And so, we prepared our motion, and on the day before the motion, he consented to the order. So all of that work was for nothing. And we had, as part of the adjournment, we had a preservation order that they weren't going to do anything with the property until the return date of the motion, which was 6 months later because everything takes time out in Brampton. And 6 months later, on the eve of the motion, the Rule 45, what I thought was a Rule 45 motion, I got a call from the lawyer at Bennett Jones, who had been on for the title insurer for the owner of that property. And he called me and he said, I've just learned that the property was sold. Because my client was in default under the vendor take-back mortgage, and the mortgagee, who was the original mortgagee, sold the property. And that's when it was clear that something was very off. And the Rule 45 motion, it was basically we had to prepare, in a matter of 36 hours, new materials, and we sought and obtained a Mareva injunction against all of the parties. And that's when what started out as a fairly contained claim sort of exploded into this much bigger thing with many different parties every director of every company got named personally, new claims got issued, and it became, a much more difficult case to manage.
Tell me a little bit about the Mareva. Is that when you sort of felt like you had turned the ship around a bit? And because the sense I'm getting is there's procedural gamesmanship. There's still a lot of shadiness going on. You still don't really quite know the relationships between these seemingly unrelated parties. But then Mareva is a very powerful remedy.
It is. And at that point, I knew that this was all bad, that there was real problems here, and that the people who I don't say I was giving the benefit of the doubt, but I had sort of been treating the allegations with kid gloves. I knew now this is a complete scheme that's going on, and a conspiracy of sorts. And so we got the Mareva, we issued new claims, and of course, as you know, Mareva freezes assets and doesn't permit people to deal with their assets. And typically a Mareva is dealt with in fairly short order. You bring that Mareva motion, and the people who are subject to the Mareva, if it's not justified, they're gonna attack it, and they're gonna deal with it. And in this case, a number of the parties just didn't respond. And so the Marevas just sat, and another indicator that something was off. And the principal, who was in the middle of it all, he responded, but then he hired a new lawyer. This was by then the company's fourth lawyer. And they responded to the Mareva, but then it was adjourned for months, which is another sort of indicator that if they're prepared to sit and wait I think it was from October of 2019, and we set dates for the hearing of the Mareva, because I got it ex parte, because it was effectively, so we had this rush when we had to convert a Rule 45 to a Mareva, and the judge who granted the Mareva she saw what was happening, and so we got a very good endorsement from her. And then the Mareva sat for 8 months, and then the pandemic hit. And so that was just more complication.
Tell me a little bit about the players and who was involved. These principals, these investors, and what was their story?
Well, I still don't know their story, to tell you the truth, because they all disappear like a puff of smoke when you get too close to them. The one person that is sort of in the center of it, he's a lawyer, has no real visibility online. No, he's kind of like a ghost, but he's a real person, and he does show up. He's a lawyer. As the story unfolds, he becomes a more prominent character in it. The other principals of the numbered companies that were involved, a couple of them got examined. One of them is in fact a nurse, a nurse out at one of the hospitals, but he got involved with this guy, with this lender, and he was part of the conspiracy, but he's just disappeared as well. And ultimately, our objective was to get these properties back. And so eventually, once the properties were sort of buttoned down, I had to focus on getting the properties back. And dealing with all of these peripheral people and going after them, I haven't. That's still sort of on the back burner.
So tell us how the story unfolds, and take us through all the number of motions and other events that happened.
Okay, well, I'll focus on the main ones, because there were many, many, many motions, and if I was to go through all of them, we'd be here till midnight. So I don't think you want to do that. The case ended up being case managed by a judge out in Brampton. It's been case managed twice. The first judge that case managed it and this was another learning experience. She was quite a junior judge, a recent appointment, and really struggled with it because there were a lot of personalities, there were a lot of parties to manage, and she was very, very concerned about giving everyone there. And this is, I'm not criticizing this, but everyone got their due process. And so whenever there was an affidavit, oh well, we have to have cross examinations, and you've got to have the right to respond. And so it was a perfect environment for people who want to stonewall and delay to use a judge to stonewall and delay by producing things late, requesting cross examinations. So the judge who case managed it originally had it for about a year, and this is when the pandemic hit. And we ended up having the first Mareva hearing on the substance of the case in 2020. So July 20, a year after the Mareva was granted, we ended up on a 2-day hearing for the substance of the Mareva. And at the end of that 2-day hearing, the principal defendant had refused to produce the appraisals that he said he had obtained on these properties during the initial sale, now 2 years before. And I hammered away at that in the Mareva as being, if these were legitimate sales for fair market value, those appraisals would have been produced. And it was just a no-brainer as far as I was concerned. And I hammered away at that. And at the night before the last day of the Mareva, when we were just going to deal with costs, he agreed to produce the appraisals and sought an adjournment. And I begged the case management judge who was hearing the Mareva not to grant the adjournment, but she did. And that invited another year of delay because he produced the appraisals, and then there were more cross-examinations. And that just created more chaos and havoc and more delay. So we never got a decision on that Mareva because that judge ended up coming under siege by the lawyer principal of the lender who sought her recusal from the case for a variety of reasons. And so she backed off, and the Mareva ended up having to be heard basically de novo by Justice Peterson in Brampton over the course of 2 days in 2022. So here we are 3 years after the Mareva was issued, and we are now arguing it basically for the second time de novo.
That's super frustrating. I mean, I could just imagine, in the judge's chambers, what they're thinking about this case as it's been years and the shenanigans.
Yep.
So, I mean, presumably that's what got you, the senior regional judge to appoint himself case manager.
Eventually, that's what happened. After the 2 days of the Mareva hearing before Justice Peterson, where she heard it de novo, we got 2 very, very good endorsements from Justice Peterson that really made it very difficult for the defendants to sort of recover in the eyes of the court, because there was just there were 60, 70-page decisions, and there was a lot of evidence, and the evidence they had advanced was pretty thin for the most part. And she's a pretty astute judge, and she was sort of she gave us we got a couple of very good decisions that gave us a lot of momentum. And eventually what happened, and this is sort of a side part of the story, is that the lawyer for one of the lawyers for this lender, the principal, I sought an adjournment of one of our motions, the recusal motion that he was intending on bringing, because I had a personal health issue that came up, and he wouldn't agree to the adjournment. And he sent a scathing email to the judge's secretary about this whole issue. And I think that ended up with the SRJ or the RSJ in Brampton, who sent a letter that's all public record now, basically admonishing the lawyer for writing this letter to court staff that was disrespectful and inappropriate, contrary to the Law Society's rules of conduct for lawyers. And at that point, the RSG sort of took control of the case and started taking all the motions. Everything had to go through him. That was Justice Ricchetti. And that was in about 2022 when he started case managing it. In July of 2022. And what had happened then is and this is another, just for the interest of the people watching, one of the very sneaky things that they did is so these people who still own these properties at the time, they just stopped paying taxes on them. And so now in 2022, 4 years later, they never paid taxes. And eventually, because I had a CPL on these properties, I got in our firm a notice of a tax sale. And so the property was going to be sold by way of a tax sale. And I got this thing and I thought, they haven't paid taxes in 4 years. And I suspect what was going to happen is that if I didn't get notice of it, this guy was just going to go in and buy it at a tax sale, and that would get rid of the CPL. So I was forced to bring another motion. I brought a Rule 45 motion for a judicial sale of the property and have the money paid into court. And it was opposed. And then the mortgagee on that property in Caledon appeared out of nowhere and paid the tax arrears. So that was another motion that I had to bring that ended up being unnecessary because the taxes got paid. And it was at that point that Justice Ricchetti seemed to sort of say, okay, this case is becoming a problem for our court because there were so many motions, there were so many lawyers involved, and it was taking up court time. And I think he was tired of it. And so he took control of it. And that's when we ended up getting a timetable for discoveries. And then some of the parties did show up for discoveries. And then we ended up with our substantive motions, which started in January 2023 is when we started the motions. And the strategy by that point was I wasn't going to try and push the whole case towards a trial because it would have been, there were too many people, too many parties. And I just thought, okay, I'm going to bring a motion for summary judgment against, try and pick them off one at a time. And that's what I did. And because when you pick them off one at a time, the person that you're trying to pick off, the owner of one property, for instance, they couldn't respond because they were fake owners. And so they couldn't reveal themselves. And so in one case, they just didn't respond and their defense got struck and we got the property transferred back to us or to my client. But then the mortgage on that property was still in place. So we had to then go after the mortgagee. So we brought another summary judgment motion against the mortgagee. And that mortgagee on the summary judgment motion, and this is a recent reported decision, they didn't file materials. They argued it, they filed a factum, but they didn't file responding materials. And of course, in a summary judgment motion, you've got to put your best foot forward. And they didn't put any foot forward. They just put a factum together. And Justice Ricchetti granted the relief that the mortgage got discharged. And they appealed that to the Court of Appeal. And that was the appeal that was heard 2 months ago.
What did the Court of Appeal say about that?
Court of Appeal upheld Justice Ricchetti's decision and the mortgage was discharged. And so now my client owns the property mortgage-free. The second property, we did the same thing. We brought a motion for summary judgment and for an order that the mortgage on that property was fraudulent conveyance. And the owner of that property didn't respond. So, of course, the owner of a property doesn't respond. It's a pretty clear indication that they're part of the scheme. So we got that order. The mortgagee on that property did respond, but and this is in, I think, the decision you may have read, where the lender ended up examining an individual in Russia who claimed to be the director of the company that loaned the money to the buyer to purchase that property. And he came up with a completely preposterous story about giving someone 500,000 euros that he met in Turkey that was going to then send the money back to Canada to invest in mortgages. And he told the story. They showed up, they argued it, and Justice Ricchetti wasn't buying it.
Wow. The result is astounding. Your client comes in having lost 2 properties due to predatory lending and leaves with 2 properties with no mortgages.
He leaves with 2 properties with no mortgages. So it turned out to be, it was a good outcome for him. There are still parts of the case that are extant that haven't been resolved, and it remains to be seen how that's going to play out. Because again, it becomes there's a cost benefit to chasing people. We have $170,000 in cost orders against a number of different parties, including the primary lender, who is a lawyer. We have cost orders against him personally, and they just haven't been paid. And the cost of pursuing those recovery under those cost orders becomes problematic.
Yeah, that's always the underbelly, isn't it?
It is. It's it's sort of like when you argue about costs, it often costs more than the costs you're arguing about. And the same goes when you're chasing down costs. If people are good at hiding money and at avoiding responsibility for payment, they make you work for it, and that becomes problematic. The one thing I would mention that there's just so many threads to this story that it's difficult to capture them all is, and this is again reported decisions that I'm not giving anything away. When Justice Ricchetti got involved, when he sent that letter admonishing the lawyer for this inappropriate communication, that party, the principal, sued Justice Ricchetti personally and sued the Attorney General in two different applications. And the AG brought motions to strike, and Justice Daly, I believe in Brampton, heard those applications, and the applications were brought against my client too. Like, for whatever, they were completely ill-conceived, ridiculous. It was a completely self-inflicted wound by this guy who did this, because he ends up having multiple decisions out of the Brampton courthouse about his case suing the RSJ in Brampton. And so I don't know what he expected was going to happen, but it didn't turn out well. And he appealed those decisions. And we went to the Court of Appeal on those decisions about a year ago. And the Court of Appeal dismissed the appeals, upheld the decisions, but was surprisingly, we didn't get substantial indemnity costs. I was surprised at how, I don't want to say they were gracious with him. I don't think they were impressed with what he had done, but they didn't come down on him like a ton of bricks. He got his hearing, he got his day in court. His appeal was dismissed with negligible costs against him. But his reputation will be what it is because of that.
Indeed. So, what are the key takeaways? Actually, you know what? Before we talk about that, remind me, how many motions, how many reported decisions in this one case?
Well, Areta, I don't even know. I mean, there were, at least 10 significant motions. Not all of them heard. Like, some of them, subject to a case conference. They're like the power, the motion to sell the property because it was under a tax sale. Motion brought, case conference to deal with the timetable, disappears into nothing because the issue gets resolved. Motion to amend the claim brought, almost argued, but then consented at the last minute. There were a bunch of those, but probably 10 significant motions that we were forced to bring. And each one is, the bigger ones are expensive. They're costly. They're time consuming. So, pretty burdensome case, if I can put it that way.
And yes, and that actually leads me to the question I was asking before, which is, what are the key takeaways from this case?
The takeaways for me. So I made an argument to Justice Daly in the application where we were sued together with the RSJ and the Attorney General. By this point, we'd been at it for 5 years, and I knew the game. And I made the pitch to him that what was happening was the weaponization of the rules in order to obstruct and stonewall and deprive people of their day in court, because the rules provide all of these push points and tools for people who are opportunistic and who don't want to play by the rules to do just that. The takeaway for me was that the system is not geared to deal with people like this. It's sort of not to get too deep into politics, but we live in an age of shamelessness. There's lots of talk about what happens south of the border. That there's a culture of shamelessness. You can say and do anything, and there's going to be no accountability. And that's really what I've seen. Takeaway for me has been watching people do things like suing a judge. I mean, who does that? I often would sit at home at night and think, I'd be sick to my stomach sitting here thinking I've sued a judge and I'm going to have to spend my career appearing before judges. And the people who are involved in this they just don't care. And so you weaponize the rules to victimize people who are already marginalized. And there's a number. I will say the other thing is that I'm in touch with 3 or 4 other lawyers who have cases with this same group of people. And so we share information and we've talked over the years about what's happening in our respective cases. So I don't know. I think I'm the tip of the iceberg, and the people who are involved in this probably have lost $1 million in terms of the money they've paid out to discharge mortgages and to buy the property and to deal with it. Paid a lot of money, but I don't know if it even makes a dent, because there's a lot of people out there that are vulnerable, that are getting victimized. And that's sort of the main takeaway for me is, if you've got a borrower who's prepared to pay 15 or 20% for a mortgage, a lender knows they're going to default. And if they want to take advantage, they can, because the system here is not set up to, it's a good faith system. And if people want to take advantage, they're able to do that.
Well, obviously, I think the fact that he sued Justice Richetti shows that there's some impact there. It's almost like striking out. There's some bitterness there on his part, I think.
Well,
in addition to the $1 million, who knows, right? But that's a very interesting reaction.
Yeah, it was. I think it was a self-inflicted wound, frankly. But people don't always act rationally. But the system was not set up to deal with these people.
And not that I'm going to ask you to pin you down on this, but do you think that there's anything in the new proposals for the changes to the rules of civil procedure that might help, or maybe they'll hinder plaintiffs faced with this kind of defendant?
I don't know enough about. I mean, I know the broad brush of what is being proposed, and I don't think it's going to impact this. I mean, to the extent that, one of the things that was weaponized in this case was the discovery process and being able to really force people to, and just avoiding doing things and forcing people to bring motions to get relief, right? And if you've got to wait 6 months to get a motion date, or if you've got to bring an urgent motion, if you've been to triage court lately, it's expensive and it's costly. And so getting rid of, and I don't think the new proposals are going to get rid of motions. They're going to maybe get rid of discoveries or maybe pare back discoveries, but I don't see this. That changing the opportunistic setup of our system. People who have money will be able to, if they choose to, victimize people who don't.
Yeah, and that's the problem for these victims is because even if we front load the system, that's so expensive that there may be a lot of lawyers who just say, you know what, can't risk it.
Well, that is the problem, right? Like if someone comes into a lawyer's office with this kind of problem, they're gonna in most cases be asked for a $10,000 retainer just for someone to look through the file and get their arms around it and maybe put a pleading out there. And these people, the people who are losing their properties, they can't make their mortgage payment. They can't afford lawyers. And really for like I have a number of these cases on the go. But there's only so many you can absorb. You just can't absorb endless work that you're not getting paid for.
I agree.
So you take on what you can.
For that reason, I'm rooting for you. I'm hoping you get those costs.
Well, we'll see. Time will tell.
Indeed. Well, thank you so much, Neil. Such a pleasure having you here today and speaking with you. Fascinating.
Well, thank you for having me. Pleasure to chat with you. And we'll see you at the next gig.
That's right.